Hello, my name is Ruth Carter, and I'm a licensed attorney in Arizona. And this is your question of the day. So, somebody asked me. They said, I accepted a job as a customer service rep for an IT company. This company put into my onboarding documents that I had to assign all rights and ownership of, not just what I was creating during my employment, but what I would create after I left the company. If I did not list what I already had invented under the exclusions, and if my idea was not listed, then I would have to agree to transfer all rights or ownership to the company. My job doesn't require me to invent anything. Why would they include all of this? All right. So this is not an uncommon thing to see in employment documents. Even if you're not inventing anything, you might be creating things for the company, which would still have intellectual property rights, even if they aren't an invention. So I've seen documents like this. I've worked with clients who had a side gig that the company knew about, had nothing to do with their employment, where we were able to carve out, like, these things are not, the company can't, has no claim to these. Um, the part that puzzles me is anything you create after you leave the company. I would wonder, okay, if you created something using like proprietary information from the company, that would be one thing, but just create in general, that seems overly broad, and that's worth asking the question of, wait a second. If I leave here and 10 years from now, I do something completely different, you're claiming you have rights to that? Like, that doesn't make sense. So, yeah. And I've never been in a situation where someone walked away from the table if someone was asking a reasonable question and doing it respectfully. So I see nothing wrong with asking the question of, what do you mean by this? Because this seems overly broad. And to try to nail down what the company's actually concerned about and then ask them to revise the contract accordingly. Because, yeah, it doesn't make sense that if you're doing something completely different than what the company does, that they should have any rights to it. So, but in general, anything that you create in the scope of your employment, or maybe anything created using company materials or information, I could see that being a situation where the company wants to lay a claim to it, or if you use company resources. So this may be a situation where you want to negotiate with your employer yourself, or farm it out to a lawyer to help you revise the contract. First, ask your employer if it can be revised, because I've seen situations where people have invested in trying to negotiate where the company comes back with like, hey, this is take it or leave it. And you've invested the money in a lawyer and it went nowhere. So I hope this gives you a starting place to ask some questions about what they really mean by this and get some clarification, because the way you make it sound, it's a little overly broad for my liking. So not the way I would want to write the contract. Anyway, of course, watching this video does not create an attorney-client relationship with any viewer. It's merely legal information, not legal advice. If you need legal advice, go hire somebody. I put out new content every week, so please subscribe to the channel. And until then, I will catch up with you later. Take care.